Thank you again for staying with us. Well, the judiciary will most certainly play a significant role in the year ahead, especially as we build up to the general elections. And well, joining us to discuss some of these issues to be raised are Victor Okpara, who is a senior advocate of Nigeria, as well as Chiman Naji, a legal practitioner. Gentlemen, thank you so much for being a part of our conversation this morning.
Thank you. Good morning.
Morning. Let me begin with Mr. Okpara. This statement that we saw just before we came on, ascribed to the President of the Federal Republic of Nigeria about the judiciary, is quite a strong one. He says, and I quote, and it may come up for you to see, as the 2023 general elections draws near, the significance of the legal profession becomes even more pronounced, considering the vital roles you play in the electioneering process, both at the pre- and post-election stages. I hope you maintain the position of an honest arbiter. Now, we all know the importance of the judiciary. What are your comments on this statement by the president? Do you see an issue which could be responsible for the president making that statement?
Well, thank you very much. It is not in dispute that the judiciary has a strong role to play when we're talking of pre-election and post-election matters. But having said that, the judiciary, as it were, operates within the country called Nigeria. And you will see that the judiciary has done a lot to ensure that it takes steps towards realizing its major role as a constitutional arbiter. Take an example of let's take an example. If you look at the Federal High Court, for example, you will see that the Honorable Chief Judge of the Federal High Court, exercising powers conferred on him on his lordship, has promulgated, as it were, practice directions regarding pre-election matters. And the whole aim of the practice direction is to ensure speedy and fair administration of justice when it comes to litigation in relation to pre-election matters. And you realize that in doing this, the Federal High Court that actually saddled substantially with listening to pre-election litigation by virtue of the provisions of the Electoral Act, has done a lot to ensure that when it comes to pre-election litigation, parties can approach the courts and at the end of the day, be assured of speedy administration of justice, be assured that at the end of the day, they will get justice.
Well, just a moment, Mr. Okpara. My apologies. I am asking concerning the statement of the president, making those statements and saying that he hopes that the judiciary maintains the position of an honest arbiter. I was just wondering if there were some vulnerabilities that the president may have seen, perhaps our historical experience in electioneering that could have made him to say this. And if you think there are laws now that have made that statement of the president even stronger, or the judiciary better positioned to do what it is constitutionally empowered to do? That's for you, Mr. Okpara.
Pardon me, I didn't.
Can you hear me now?
Yes, I can hear you now.
Okay. I said the question was around the president's statement that we showed you earlier on the screen, that the position, the expectations of the constitution of the country is very, very high. So I'm wondering if the constitution is clear what the function of the judiciary is. Why make that statement? Were there vulnerabilities? Were there things that could have made the judiciary vulnerable or perhaps culpable, some people might say, before now, that going forward towards the 2023 general elections, those things the judiciary will step ahead of?
Well, thank you. Well, thank you so much. Going forward, I wouldn't know what's operating in the president's mind when he made that statement, but I can tell you for sure that the judiciary itself is not a perfect organ of government. And that is why there are inbuilt self-cleansing mechanisms to correct any mistake that the judiciary makes. If, for example, you have a pre-election matter that has to do with, let's say, National Assembly elections, there's a filtration process that terminates at the Court of Appeal. And if it's a gubernatorial pre-election matter, there's a filtration process that terminates at the Supreme Court. So basically, on those tiers of those self-cleansing tiers, you'll find a situation where at least the judiciary will be up to task and ensure that at the end of the day, it delivers even-handed justice. Of course, we cannot feign ignorance of the fact that at times, there have been situations where a judgment that people expect to go this way has gone that way. But of course, that is not how the judiciary works. It's a question of what evidence you have brought before the court. It's a question of how you prove your case. It's a question of what was before the court. And at the end of the day, you can travel all that length, and at the end of the day, when it gets to the final court, which is the Supreme Court renders a decision, and that stands binding. Well, it doesn't mean that the decision given by the Supreme Court is, I mean, the Supreme Court cannot play God, but of course, that is the final decision of the court, and we need to be bound by it.
Okay. Well, now that you mentioned the Supreme Court, let me go to Mr. Naji. Part of the comments ascribed to the CJN recently is, look, there are some cases that shouldn't go as far as the Supreme Court. Let me see if I can quote him as well in his own comments, concerning what the judiciary ought to do. There are many matters that should not find their way to the Supreme Court in 2022. Many are indeed domestic matters of the political parties. Why bring that to the court for us to adjudicate when your constitution, that's the party constitution, has shown you the way? Follow the way, Justice Ariwala has said. Mr. Naji, what's your take on it? Is there anything within our laws now that makes that something that is feasible?
Thank you very much, and good morning, viewers.
Go ahead, we can hear you. Yes, go ahead.
Very well, very well. All the exhortations, both from the president, the question you asked the Leonard Seal, and the one, the CJN, I believe when he was being inaugurated, made that statement of exhortation. Both of them are right. But you see, the problem is a situation where the judiciary has now been placed in a position of higher authority to determine the electoral success of candidates rather than the voters. That is why it is impossible that when you say you should be laden with the weight of the world and it is placed on your head, your neck will not carry it. It's a question of fact. The judiciary is now complaining. At the initial stage, it appeared the lawyers were enjoying the largesse that come from bills, that politicians were ready to pay. So when you find that all matters of all colorations, trivialities are coming up to the Supreme Court, including landlord and tenant cases, where a tenant will stay in a property for 10 years because of the unfortunate development where the judges at the Supreme Court are limited. The judges at the appeal court are limited. It's like a pyramid. The base of the pyramid is the lower court. They are higher in number and can afford to accommodate some of those cases. So what the CJN was in essence talking about is to reduce the unnecessary workload so that you improve the quality of judgments and the quality of life of those who deliver the judgment. Remember that the Supreme Court only just recently is about to talk about, it's about talking about electronic application of electronic facilities to enhance performance. In some courts, especially outside Lagos, you don't have such facilities. And that is judges, even lawyers themselves, sitting down to read and write and draft is enough problem. Not to talk about a judge that has to accommodate all these things coming from more than 4 lawyers or 10 lawyers, depending on the nature of the case and the parties at the court. So what the Supreme Court and the CJN was saying is reduce the workload on the apex court, even not only for electoral cases. I, of course, and many other well-meaning lawyers have been saying that Supreme Court should no longer hear cases of landlord and tenant, just such local cases that can stop even at the Court of Appeal of the division in that particular area or zone. So that is a very germane exhortation. But are we going to be able to see a development so soon where such discipline can be implemented? Because it appears there are certain economic benefits by some of those people who want to perpetuate and perpetrate it.
Well, Mr. Naji, to perhaps further take what you just said a little further, one of the things I also ascribe to the CGN is that, look, he said politicians should stay politicians. The same way you are saying that landlord cases and tenant cases should remain where they ought to be. Politicians should be politicians, let the judiciary be the judiciary. But then we have lawyers in political parties. We have election cases that have to go to the courts and all of that. So some of the issues within the judiciary cannot be far from the practitioners within the judiciary. Do you see mechanisms strong enough to ensure that practitioners within the industry, within the judiciary, play by the book, both the Constitution and the laws that govern elections, as well as perhaps the parties' constitutions themselves?
My dear, the truth of the matter is that you cannot change Nigerian politicians. The Nigerian politician is a special breed. Special in the sense that the circumstance in which he operates, he or she, I mean, seem to engender certain characteristics that are novel to the art and practice of politics. One, integrity is a very rare commodity. You may have had a good pastor keeping the shepherd. Once he says, I am now joining into politics, he is baptized in the spirit of lying and all chicaneries and shenanigans. He's the same man, but he has changed. So if you say, in psychology, they say, if you can't change the person, change his circumstance and situation. When the police officer or commissioner says, armed robbers, be warned, leave my state, I have just been posted, he's just playing to the gallery. In the same manner, it is not possible for the CJN to caution politicians and expect results, except that he had to say what he needed to have said. At least somebody must say something. Politicians will not listen to you because their interest is at stake.
But some of these politicians, Mr. Naji, are lawyers who ought to know better, who know the Constitution and the law.
Knowledge of the law has not prevented those who want to, even in the legal practice, you have bad eggs, who use the law to further their practice of, let me just say, lack of integrity, dishonesty. The point is that if you want to change the system, if the people are not going with you, make an intelligent change in some of those things that make them, if you want somebody to leave the room where he's so comfortable, turn off the AC. When he starts feeling hot, he will get out of the room without even being prompted.
Okay. Well, let me ask, my apologies, let me ask Mr. Okwara the same question, especially concerning practitioners, legal practitioners who also practice politics, because we're talking about 2023 elections and the judiciary. Most certainly, we cannot divorce the judiciary from the 2023 elections. What is interesting is that there are practitioners within our country, within the judiciary, who stride both politics and the judiciary. And some of the issues that we have had, and we may have, as we build up to the 2023 elections, cannot be far from some of them. Do you see a strong enough system or parameters within the judiciary that can help maintain or insulate the sanctity of the judiciary even though some of the politicians are members of the judiciary?
Well, thank you so much. Well, I think that electoral litigation is not an all-comers affair. And if you look at the provisions of the Electoral Act 2022, the practice direction for pre-election matters, the Constitution, you will notice that there are parameters put in place to cage some of these desperate politicians. For example, it is true that it is a prerogative of political parties to sponsor, nominate, and present candidates to the INEC. However, there is a statutory caveat, and that caveat is just a little window. And you can see that in the provision of Section 84, subsection 14 of the Electoral Act of 2022. And the window is very narrow. It says an aspirant who complains that a political party has not followed its own guidelines, or a political party has taken steps or conducted itself in a way that is against the Electoral Act or the Constitution, then the aspirant can now go to court and ventilate his rights or passive rights. Who is an aspirant? An aspirant, for the purposes of a pre-election litigation, it's a person who participated in the primary election. So it's no longer an all-comers affair, where any person who is a member of the political party can just go to court and begin to challenge the primary election. Now, if you look at the practice directions, for example, of 2022, made by my Lord Honorable CJ of the Federation of the Federal High Court, there is a provision there that says, look, if you want to challenge a primary election, you must join now. You must join the candidate that was presented by the political party as being their judge winner. Now, if you look at the provisions of Section 29, subsection 5, I think, of the new Electoral Act, it is only an aspirant now that can say, look, I'm challenging the primary election of Mr. A, who emerged victorious on grounds that he submitted a false certificate or false academic credentials. So there is a statutory and constitutional parameter for ventilating rights now. So it is no longer an all-comers affair. So the politicians that are used to now inundating the courts with a litany of litigation,
oh dear, I'm pretty sure that we're going to get Mr. Okpara back. Okay. Go ahead, please. Go ahead. Oh dear.
And that sufficient interest is limited to where you are an aspirant in the particular election you seek to set aside, or you seek the judiciary to review. So and there are so many other provisions of the Electoral Act of 2022 that are in place now to checkmate some of all these activities of politicians. But of course, having said that, we are human, and it may not be perfect, and these particular constitutional and statutory parameters to actually curtail some of the excesses of these politicians may not take us to the promised land today. But
Okay, I believe that perhaps there are some issues. I'm pretty sure we'll get back to him. Well, Mr. Naji, let's come back to you as well. Well, oh dear, I understand that both of them are not available at this moment, but we'll make effort to get them back. Perhaps look at those slides again. But, you know, Chamberlain, you know, there is that, I don't know if you will recall that conversation we had with Mr. Egene, who, by the way, has been taking us through, what will I call a lecture series of sorts on the Electoral Act and the need for politicians to be on their toes at that. But I'm not sure how to even begin to tell, you know, maybe the lawyers who are politicians, whether or not there is a need for them to really get into the throes of it. I hope we'll be able to get the gentleman back, Chamberlain.
Yeah, well, hopefully when they do, because, I mean, don't forget this component where The Federal High Court did constitute a special task force of judges to swiftly hear and determine all pre-election cases before it. So the importance of addressing all of this electoral litigation is very, very valid. I mean, if you look through some of the reportage today, you get to see how the courts will be playing a very huge role. I mean, some of the lawyers there also spoke about the importance, ensuring that we don't let the courts begin to perform the functions that the people ordinarily themselves should be in terms of voting, and ensuring that those who are voted for by the people, it stays that way, and not for some extraneous reasons, as it were, by the courts, things change, which many have seen happen over time, and that is not exactly a good scenario. Not that the courts will not entertain whatever is brought before them, of course they will, but there's a huge call, there's a huge importance to ensuring that all of those things are done right, because a lot of these things feed into these scenarios where if the people feel that the persons or the people that we elected are not the ones who are in the driving seat, it will always breed some sort of disagreement, dissent, all those kind of challenges. So it is a very important component, and that is where there needs to be vigilance on our part, on everybody's part. And the judiciary, I mean, you get to hear them say, much as they don't decide their cases based on what we see or read or hear in the court of public opinion, but, you know, it's really going to be interesting how some of the cases we understand that before the courts, if they go that way, you know that they will have a huge impact in terms of how things turn out. So I'd like to hear what you all think about some of these matters, the expectations from the judiciary. I mean, not that they don't know what they have to do, the judiciary, concerning those cases, but they also say justice must not just be done, it must be seen by you and I now, members of the public. It must be seen to have been done. So that's just how it needs to be. That's what we look forward to at the moment.
Well, I guess you know the time is the determiner of most of these things that we're talking about. The 2023 elections is just about 114 days away. I know, because yesterday was 115. So, and you know, it's just for us also to count down, so to speak. There was something you hinted at sometime before now, Chamberlain, and that's the fact that we all need to pay attention to the laws that govern this election. Not just the politicians, not just the lawyers, the average Nigerian as well. Not just to know that everyone knows what to do and they should do it, but we should ensure that we know what they ought to do and they actually go ahead and do it. For instance, what is the function of the voter at the election, at the polling unit? What are the functions? Do I just vote and go home, or vote and ensure that my vote counts? Those issues are very, very important for us all to be aware of, irrespective of whatever the members of the judiciary are doing, members of the political class are doing. We ourselves also have our functions in law to do what we need to do. Well, perhaps it's a good time for us, Chamberlain, to thank our gentlemen. Well, unfortunately, we may not be able to bring them back. Okay, I understand that one of them is a runner. Mr. Chiman Naji is back with us. We're trying to get him back to have his final moments with us on the program this morning, because those issues are actually quite important. One of the issues that I'm very much interested in, Chamberlain, is how do we ensure that the lawyers who are politicians do not take undue advantage of what they would call loopholes in law to some pecuniary interests as opposed to national interest. It'll be very, very interesting to find out what Mr. Naji, would have to say about that if he has already joined us. Because, okay, well, Mr. Naji, you may want to speak to that. How do we ensure that we have national interests supersede personal, political, or other interests that may play up, especially as we build up to the elections ahead?
Very well. Like I said, if the person cannot change his situation, he will respond to that situation more than mere exhortations. There have been some effort through the agitations of Nigerian citizens who have been at the raw end of the stick on this issue of electoral outings over the years to insist that we have a paradigm shift from the way things were done under the old laws. Now, with the 2022 Electoral Act, they have, yes, the learned LCN has also alluded to the statutory impediment to having an avalanche of candidates coming to court just to see if somebody will settle them along the line. But this is still Nigeria. Even if you have 4 people contest election, the other person winning, 3 might decide to go to court if the other party, if the winning party refuses to settle. And the legal principle is that once you come to court, no matter how bad your case is, the court must listen to you. And that is a principle of fair hearing. And even the lower court can give a terribly bad judgment, and that remains the law until it is upstaged at appeal. So these are principles of law which the lawyers themselves will also want to exploit if they don't have integrity. But a lawyer that has integrity may not always want to be seen at the corridors of court every hour just because he wants to wear the wig and gown.
But isn't integrity one of the core tenets of the judiciary?
Integrity is even taught at every level of the law school, and it is expected to be the DNA of the judiciary. But just like even the medical doctor is taught how to save life, have we not seen doctors that are taking lives? So even after taking the Hippocratic vow, the issue is that there will always be an exception to the general rule. And some of these exceptions are usually most dangerous, disruptive, and boisterous, so that they will encapsulate and mask all the good ones people have been doing. The whole essence is that the people should begin to insist that judiciary should play a lesser role in determination of who the candidates should be. I mean, the success of candidates at the polls. So that what they say at the polls will count. The electoral, the polling booth is said to be the most silent killer. But today it is those who voted that are killed rather than those who should be receiving the pain. So what we are saying is that nobody should place 100% reliance on anybody who have been taught about integrity, because his circumstance might impel otherwise. But if you change the circumstance, when those people derail, there should be acute and condign punishment for that.
Okay. Well, Mr. Naji, unfortunately, I mean, you talked about the medical practice the other time. Unfortunately, we're not talking about them. We're talking about yours. When we have them, we'll most certainly raise that as well. Okay. We have to thank you very much for being a part of our conversation this morning. Chiman Naji is a legal practitioner. Thank you so much for being a part of our conversation this morning. Truly appreciate it. We have also had with us Victor Okpara, Senior Advocate of Nigeria. Unfortunately, we're unable to have him.